Thank you, everyone. This is Jeff Foley with Paladin Financial, and we appreciate you tuning in to this week's episode of Paladin Financial Talk. We've got a great show today, but first of all, wanted to point out my attire here today. Usually wear a suit. Today, not so much. We're today, December, 22nd?
Yeah.
21st. So Thursday, dressing down a little bit today, so apologies.
Oh, no, you got to sport the local team pride, right?
That's right. First time I've been allowed back on the podcast in a while, and I show up like this. But, hey, that's all right. But, yeah, we got a great show today. Before we wrap up the end of the year, we're going to talk about some estate planning questions and topics. So we have a special guest here. Well, two special guests. Tony, you're always special. And also Mr. Matt Tramm. Matt Tramm is an estate planning attorney, works with a lot of our clients with Tramm Law. So welcome, Matt.
Thanks, Jeff.
And he's repeat. We've had him. You've been on here before, been a little bit, but we have some great things we're going to talk about, and we'll kick off here and first discuss what are some common questions, Matt, that you get with estate planning clients that come up. What are some things that you hear the most from people?
Yeah, so people are coming to me usually with a little bit of knowledge, maybe just enough knowledge to be dangerous. And so I am getting a lot of people that are asking about an instrument called a trust. Okay, and so a lot of people, I'd say that if you were to say what's the most common question, it's going to be, what is the difference between a will and a trust? And I might even expand that to a will-based plan versus a trust-based estate plan. So we're getting that question a lot, and there's good information out there on the internet. I think there's so much, though, that it confuses people, leading to that question being on a lot of people's minds.
That's good. Good. Yeah, that's a common one that we hear from folks as well, and people have assumptions on, I need this one or I need that one, and I've learned along the way, and don't assume too much, and that's where you come in to help people sort out. Yeah, it's not just an asset question, is it?
Yeah, well, so there's a I think it's a human need to say, I want a set boundary, and you need to tell me what the criteria is for me needing a trust. And I've even seen people say, I have X amount of dollars. Do I need a trust?
Yep.
Okay.
Yeah.
And people would like to think about it in those terms, where it's a cut and dry, formula that they can run on themselves. And really, if you have an estate planner that's interested in the client, maybe rather than just pumping out a set document or something, the examination should actually look back to the client's situation to say, what are your goals here? What are you trying to accomplish? And I always kind of like to look at, who do you want to leave something to? Okay, if it's one person, that might be a factor for me. If you're saying, as I had yesterday, I've got 12 different beneficiaries I want to leave things to, well, that's going to close some doors, maybe in using a will for me to say, if you use the will and maybe we're using some transfer on death deeds and beneficiary designations, you're looking at creating a very complicated and perhaps contentious situation, especially with real estate, which I'm sure we can talk about. But we kind of like to look at, what are you trying to accomplish, who are you leaving things to, and then what are you leaving behind? And I think that the examination of, do you need a trust or a will-based plan, is much more appropriately looked at in those terms, rather than just, I've got $700,000, do I need a trust?
Yep.
Okay,
Yeah.
so it's a little bit more nuanced.
Yeah, I think the big question, I know in dealing with my grandfather leaving his property, and my parents then, my dad inherited some farmland and a farm. And so when I met with the estate planning attorney that my grandfather had, I'm like, the big question, like my dad has, do I need a trust?
Right.
That's the first question out of everybody's mouth was, do I need a trust?
Yeah, and then to further muddy the waters for people, if they maybe are looking at their parents' plan, they'll see that their parents have a trust and they have a will. And that's something that gets people confused when maybe I'm telling them, I'm breaking one of the biggest misconceptions for people, which is, if you have a will, you still will likely have a probate. Okay, and so that's another one that people are coming in with a huge misunderstanding on that. And they think that somehow the will itself has avoided probate.
No.
Well, the will is actually the instructions that we prepare to give to the probate court.
Right.
Okay, and so a lot of times we'll have a trust, and then people will look and see, oh, my parents had a will too. The will is going to be taking the backup role. It's still going to be there, but it is going to say everything I have should be gifted to my trust, and it's now serving as a backup plan. Okay, but yeah, that's another common one is, do I need a trust?
Right.
Yeah, and if you have a will, it's not a guarantee that that will is going to be executed as is, right?
Well, so the thing that people don't understand is that the will, having a will and having it witnessed and notarized and prepared by the best attorney in the land, it is still the instruction to the probate court, meaning if I don't have a will, I'm in the same place with the person who does have the will when our estates are being administered. And so granted, we can tell the court what we want them to do, but the court still has to go through its process. And kind of what you're getting at there is that a lot of what the probate court is there to do is, first of all, it's there to protect a person's creditors. You know, we like to think that we would like to protect our family rather than our creditors. Probate's there to protect your creditor. Probate's also there to make sure that people have a forum to lodge all their complaints against you, against other family members, and it creates this opportunity for everybody to get back at maybe the family members that they've always wanted to.
Yep.
And that's where we can say, hey, you've got the will, but it's still going to be run through this long process. And most people, when they understand that, they don't want to do that.
Yeah.
Yeah.
That's good.
Yeah, and most people want to, you always hear probate bad, right?
Yeah,
I mean,
yeah.
nobody wants probate, so that's why we have a trust, is to avoid probate in many cases?
Yeah,
or?
that's a really good kind of place to dig into this a little bit. And so I always like to look at maybe a piece of real estate. And let's just say a married couple owns a home, and my wife Ashley and I own a home in Arden Hills, let's say. We can be on that deed, and both of our names can go on there, and we can look at that, and we can request the deed from the county, and we can feel a lot of peace of mind. Yep, both of our names are on there, and I know that if I pass away first, my wife Ashley will become the sole owner because we're on there as joint tenants. And so that property passed from being joint to being sole ownership by my wife. No probate, no problem. But if my wife passes away, this is where, even if Ashley and I had the best will in the world, that says this property shall be passed down to our two daughters. The problem is that Ashley's name is the only name on that deed. Okay, and now the county recorder's office who holds the deed, my daughters could go down there and say, hey, our parents have both passed away. We want to inherit this property. And the county recorder's office will say, hey, there's no reference to any transfer mechanism on this deed. You're talking about something that's in a will. Take that will to the probate court. Okay, and so now you've got the probate process. What the purpose of a trust would be, among a couple of other things that could potentially be done, but a trust can actually create an agreement between Ashley and myself to say, we agree, outside of the probate court, outside of our will, we agree that when we pass away, this property should be passed down to our daughters. Very similar to what we put in our will, but it can be put into this trust agreement. The trust agreement will generate a title of the agreement. The title then of the agreement, it could be the Ashley and Matt Tramm Living Trust, that can be put onto the deed alongside of Ashley and my name, now meaning that both of us could pass away and the name of that agreement is still on the deed. And now the county recorder's office will say, hey, this doesn't need to go through probate. Tell us what that document says, have that successor trustee in that agreement come forward, and you guys can handle this whole thing outside of probate privately, and it can be immediately passed down to the beneficiaries in that trust agreement. So that's going to be your purpose of having a trust, is to get it onto the title of the asset.
Sure.
Yeah, so the will is instructions, whereas the trust bypasses probate. So
And it's a way to actually control the asset immediately upon your passing without any delay or gap there. Okay.
And a lot of people, I don't know if you probably experienced this as well, a lot of people that might be a good candidate for having a trust costs more money than a will, but if you look at the difference between what it's going to cost to have a trust put together versus a will, and you spread that out over your lifetime, and you look at the ease of administering things in your passing, it's nothing.
It's almost non-existent, especially the way that at least we've grown our process in our firm is that the trust-based plan, which would be a plan based on having a trust, along with all the other documents that everybody should have, and a will-based plan, the cost is very similar. You know, there's kind of a floor cost of doing everybody's documents that you get with a will, and the trust is just a little bit more than that. And so really, cost would not, in my experience, be a big factor for people if they take the time to understand what it is that they're getting. And certainly probate avoidance is just one of the big benefits that some people can get from a trust. And we still do a lot of will-based plans. And you know, maybe it's worth just looking at a situation where a will-based plan can still be a good option and still be understood to avoid probate. Okay, and so where I like to use a will-based plan would be for a family, and it could be a family even with significant assets. But one of those big factors would be, does the family have a small number of beneficiaries? So if you've got an only child situation, this would kind of be something that would be a little bit of a trigger for me to say maybe a will-based plan can work, because we have the titling problem on the real estate. How do we avoid that with a will? Well, we actually can do an additional document that's called a transfer on death deed in Minnesota, and the only child's name can be put on the transfer on death deed, so that when the parents both pass away, the child's name will automatically be put on that deed through a transfer on death deed. People say, well, I've got 5 kids. I want to use that same method. I want to avoid having a trust. Let's use a transfer on death deed with my 5 children. Well, that's where I'm going to really try to put the brakes on, because what you're actually doing there with 5 beneficiaries is you're saying that when the 2 spouses pass away, there will become 5 new owners of a property, and they're not going to be the people inheriting the proceeds from the sale of the property. There's not any actual discussion about that. They will just simply become the owners of the property. So now you have a residential property, 5 owners. Maybe eventually those 5 siblings, if they don't hate each other by this point, all decide, yes, we are going to sell it. Well, now you got to say the 5 of us will all agree on the same realtor to use. That's another problem that I actually see become a real issue. And we agree to what time of the year we should sell it, what the listing price should be.
Yeah, the price is the big one.
The price
I would
thing,
assume.
and there's people who want to liquidate it. I want my money tomorrow. Let's sell it to this guy who just called who wants to offer 25 cents on the dollar. That sounds good to me. He'll put money in our pocket tonight, he said. Or you have people who say we should take a year to get the best price. You know, people are now fighting with each other.
Yeah.
Maybe they come to a place of agreement, and then the title company says, oh, by the way, in Minnesota, it's 1 to buy, but it's 2 spouses to sell. Did you guys know that your 5 spouses also need to sign off on this? And now we got to get 10 signatures. And now the spouses maybe have their designs on inflicting some pain on sister-in-law or something.
Yeah.
And so the transfer on death deed quickly becomes a nightmare situation.
Oh, I've heard, because I had heard the transfer on death deed was the way to go. But when there's multiple parties, like my grandfather, my grandfather used transfer on death for all his farmland, and he had 4 children.
Yeah.
But he didn't. It was separated out clearly and stated this 80 acres.
Right.
It transfers
and
on
we've
death
done that
to,
a lot.
to Jerry. This 80 acres transfers to my dad, Tom. And so in that case, it can work, right?
It's a really good point. And so that's just about being strategic. Don't put all the kids on all the properties. Give 1 property to each kid, and then you've still avoided that problem of having to reach this agreement with a large number of people.
Of course, if you just have 1 property, like a house, then it's hard.
And that's typical, is that you've got the house, and that's where all the equity is. And so, there's some pitfalls there to just be aware of.
Oh. You don't want to be penny wise and pound foolish.
Exactly. And that, unfortunately, is in human nature to a certain extent.
Yeah.
If you kind of peeling back the curtain, if you will, the life of an estate planning attorney, not too far. No.
Yeah, I don't want to shock you guys. Okay. Is this a PG-13 podcast, or what is this?
What would you say is the most difficult part of what you do?
So I would say it's the information gap Okay, and a common thing that I hear when we actually maybe get to the point of the process where we're signing documents is, Matt, why doesn't everybody do this? Okay, and that goes back to the most difficult part of my job, which is just reaching people. And it kind of relates to, I know, something that we'll probably talk about too, which would be, what's the biggest misconceptions? What do you struggle with? And I think it is just that information gap that people just don't know. And I think then maybe where I was going with that was that people can put this off.
Yeah.
So it's reaching them, and then actually once they understand it, getting them to take action.
Yeah. Yeah, and it's the most common thing I think that we are reminding our clients as we work through our planning process and hear all the things that need to be buttoned up to have a secure retirement and peace of mind. This is probably the most common one is you've got to get your estate plan in place. If you don't, you're on the state's plan, and here's how that's going to look.
Yeah, and I really like the way you said that, and I tell people the same thing, is that everybody actually has an estate plan. It's either you can have the one that you do, or you can have the state's default plan for you. And so I think the most difficult thing is just lighting the fire under people and then just reaching them. Okay, estate planning is the easiest thing I think to put off. So it's right up there.
Well, nobody likes to think about their own passing or talk about it or communicate with their kids or loved ones about what's going to happen, and especially my parents' generation and my grandfather's generation.
Certainly.
They never talked to anyone about their financial situation, and it's so private. So I think that's a roadblock that a lot of people face. But the advantages and the disadvantages, the reason you want to do it is you don't want to leave your loved ones in a bad situation, right? I mean, you can really destroy the harmony of a family.
Oh yeah,
so quickly.
No, it actually there's an example, and I'm an old hockey player. And in youth hockey or high school hockey maybe is what I'm thinking of, college hockey even to a certain extent, the referees are there during a game to keep everything in order. And I kind of think of the parents like the referees, and the teams can more or less, come to the end of the night and they haven't killed each other yet. Sometimes in a scrimmage or in a practice, that is where there's no referees, and you'll really see people start fighting. Okay, and I kind of think of that as the situation where the parents are gone, and the parents thought the kids would totally get along when they're gone, and I have seen there be something that changes when the parents are not there, and it's almost like the kids lose a certain connection with their sibling even. And now it does become about money. It becomes about hard feelings. And you hate to have the concept that you would not do something during your life that would put your kids at each other's throats when you pass away. So there's that element too.
Yeah. A friend of Tony and I is his family, Jay.
Yeah.
He shares the story. His mom went through this process, got her estate planning documents in order, got a trust, etc. And when it came to the household items, she was like, you guys can sort it out. I'm not going to list them out.
Very common. Yeah.
And, a lot of times that's left blank. Well, she was going to go through that route, and Jay said, no, wait a minute. You need to line these out. And when him and his siblings and the mom were talking about it, the biggest thing that they were going to have issue over was a butcher's block. It wasn't who got the cabin and the car and the money.
Isn't that crazy?
His granddad had made a nice butcher block that was kind of the centerpiece of the kitchen, and they all wanted it, and it needed to be laid out who's going to get it. And,
right. It's so true.
Wow.
And a lot of times, no one cares who gets which dollar. Okay, if you take that dollar, I'll take that dollar, and everybody's happy. Those personal items can have immense sentimental value. That really can be the source of more conflict. So the more we can get someone to think about some of that, or maybe even just decide how things will be distributed, the better. But yeah, that's a good example, Jeff, for sure.
It's good. We have coming up in a couple years now. So at the end of 2025, we've got a big change on the books currently with the federal estate tax exemption is set to sunset and roll back to what it was back in 2017. And for people that have a significant amount of assets, that number is going to drop quite a bit, and there'll be a lot of people that are currently under the federal estate tax exemption today that might be triggered with that, and this is just the federal side. Human nature is people delay, and as we just talked about, put off things that we know we should address. But for people that have assets that are going to be impacted by that, do you see people making a move yet to make changes to get under that exemption?
So we've just in the last month, we've dealt with 2 higher net worth clients that are doing some things ahead of time. I've got about 10 people who have said, let's talk after the first. And so I think there is starting to be a little gear up to try to deal with this. And Jeff, just for the audience, we currently have an exemption at the federal level that's around $13 million. That gives most Minnesotans, at least, a lot of comfort to say I probably won't be paying estate taxes if I have $13 million and my spouse has $13 million that we can give to our kids without paying federal estate taxes at the 40% plus range. Okay, that exemption level is going to be cut in half, at least in half, in 2026. Down to 5.6, and so you still need to have a lot of money to worry about that one. But sometimes people aren't even considering life insurance death benefits a part of that. People can get in that range, and they need to take action before 2026 in order to have all of their options available. Okay, so that's a big deal. Minnesota, as you mentioned, you said this is just for federal. Minnesota has their own estate tax exemption, and this is more relevant to a lot of the people that I'm working with, and that's at $3 million. Okay, and it's not even as comfortable as the federal in the sense that the federal, without getting too technical, it's got a concept called portability associated with it, where the surviving spouse can use both exemptions. In Minnesota, we don't have portability technically yet, and so maybe an estate plan would be required for the second spouse to use both $3 million exemptions if needed. And so, yeah, those are issues that people can't keep kicking down the road for too long and still have all of the benefits of that really high exemption to use in dealing with the issue before 2026.
Yeah, and the federal estate tax is what most people typically talk about, and it's significant. But you drop down to $3 million in Minnesota.
There's a lot more people in there when you're considering your retirement plans, your death benefits, equity in the house. Maybe you've got a company and you don't even know what it's worth, and so there's some pitfalls there for sure that I see dealing with even what people would think of as middle class Minnesotans.
And that Minnesota estate tax starts at 13% and gets as high as 16%, so it's not insignificant. Common question or concern or confusion point that comes up as well is you have the estate tax that the estate is paying. Can you explain the difference between the estate tax and inheritance tax?
Yeah, so Minnesota, we just do have an estate tax, okay, and that's more or less understood to mean that the estate pays that tax rather than someone getting an inheritance and then owing a tax. Okay, so there's stuff that people have in their minds from maybe the way it used to be or some other state. But Minnesota, we're dealing with an estate tax, and so that's always a good thing. I think a lot of people could just use the peace of mind to have a professional look at their situation and tell them that they don't have an estate tax problem. I've dealt with a lot of people who come in with some real stress that I think I'm going to be paying taxes or my estate will be paying taxes, and I can go through a kind of an analysis with them and tell them, no, you won't. And even just that I've seen in some of these consultations be a real point of stress relief.
Yeah. And Wisconsin, which I'm directionally challenged, but I believe is 22 miles to the east of here.
Pretty close.
So they have a transfer tax, so you have the inheritance tax that's separate. That would apply if you have property in Wisconsin, which might apply to some people on here as well. But taxes, fun stuff.
Yeah, and isn't that a large part of what estate planning is for, is to try to minimize the tax burden for your loved ones when you leave them
Yeah.
a house or property or money? Is
I'm
that
glad
part of what you do?
That's the big consideration. Now, estate planners have had it a little bit easy in the sense that some of those exemptions are so high that not everybody's having to deal with that once we can make that determination.
Sure.
However, there's a different kind of tax that I think is relevant to everybody, and this is a capital gains tax. Okay, and
Yeah.
this does directly relate to how we set up someone's estate plan, and unfortunately, there's a lot of people that are part of the do-it-yourself culture, and one of the things we see getting done in the do-it-yourself estate planning world would be, hey, before I pass away, why wouldn't I avoid this whole probate situation, and why don't I gift my properties and assets to my loved ones? Let's gift the family cabin to the kids now rather than waiting till I pass away and I've heard that I'll have a probate, etc. Let's just do a quitclaim deed and let's give the cabin to the kids. Well, I want to urge extreme caution when you start to think like that, because that could be the right move, and I don't think it would be the right move simply from an estate tax or an estate planning perspective. But where it becomes the wrong move is that we do still enjoy something called a step up in basis when we transfer an appreciated asset on a death. Meaning, I bought the cabin for $100,000. It's now worth $700,000. I don't owe any taxes until I sell it, capital gains tax. But let's just say I gift that property to my kids during my lifetime. Well, now my kids own the property. They don't owe any taxes because they haven't sold it either. But when they go to sell it, they do not owe a capital gains on the difference between $700,000 and the new appreciated value. They actually owe capital gains all the way back to the $100,000 number because that was my basis when I gifted it to them. Well, now that's yielding a huge capital gains loss, okay, because capital gains can be a very high tax rate because it's based on the person who's paying its income as well. And so there's a way around that, which would be to pass a property at death, so through the estate plan. If we can do that, pass a property or appreciate asset at death, we get a step up in basis up to the fair market value in the year that the person passed away. So in the example, my kids would now have a new basis in the property at $700,000, and if they sold it a year later for $750,000, they would only owe that capital gains on $50,000
Sure.
rather than the full $650,000 that would have been in the other situation.
Wow.
So that's a blunder that I see people making, and there's other problems with maybe gifting the property too. And I know Jeff and I have talked about this just recently, but yeah, there's some real things to pay attention to.
Yeah, we have two different situations. I have someone I'm working with. Another one of our advisors has someone that they're working with where gifting at the wrong time has created some issues that need to be dealt with that are not fun. So kind of summarizing that, if you're passing that cabin or that house away at death, your kids get a step up in basis, or whoever gets a step up in basis. If you gift that, you're passing on your cost basis to the kids, and they turn around and sell it later. They're paying gains. So.
And one thing I do see a lot of as well is people saying, oh, well, that might apply, Matt, but this is my personal residence. And I've got an exemption for capital gains. I've never had to even think about capital gains because I know that my house is worth less than $500,000, et cetera. And they're actually getting that confused because the personal exemption is not going to apply when your kids go to sell it necessarily in the same way it would if maybe you sold it. Okay,
Yep.
so you're, even on a personal residence, you're still passing along your basis. Okay, so yeah, some serious problems.
Very good. Last, maybe most important question for both of you now. We have a big day coming up. Turkey, ham, or some other option?
So I don't know where this camera cuts off, but if you can see my body, I'll be able to tell you that I'd go with both options. Turkey, and I would say turkey, ham, and whatever else is available is how I'm looking at this.
All the above.
Yeah,
exactly.
Well, for me, it was weird. On my dad's side, my grandparents always celebrated Christmas Eve every year. That was tradition. And the whole even extended family, I mean, all the aunts, uncles, cousins, relatives on both my grandma and grandpa's side would come to their house, and she made oyster stew Christmas Eve. Oh. And I've heard that's a thing. You can look it up. Christmas Eve oyster stew, and I can't stand it. I hate oysters.
I was going to say, that's
but
unique.
the broth with little oyster crackers, delicious, but not the oysters. And then ham on my mom's side, it was always ham on Christmas Day. Yeah. How about you?
Well, if I was cooking, everyone would be eating TV dinners, and we'd be dusting off those metal trays
It'd
from
be
the
pizza.
80s.
If I was in charge of the food, it would always be pizza.
Can't go wrong.
Otherwise, I'm not picky. Yeah, I'll eat
I'm
whatever's
not
in front of me.
picky. I'm just telling you what my I grew up with. That's for sure.
Yeah.
I'm like you. I'll eat whatever's put in front of me.
Exactly. And I'll eat a lot of it.
And Matt, how would people get a hold of you if they wanted to reach out and get their estate plan updated or implemented?
Yeah, so I would actually say that you and I have a really good situation going where if somebody wants a meeting with me, we actually have the ability to give them a free consultation. And that's going to be most efficiently set up when they go through you, okay? And so I know that your office has a way to set that meeting. If it's someone that maybe has to go some other route, they can just go to trammlawfirm.com, TRAMM lawfirm.com, and there's instructions and prompts on there on how to set up a consultation.
Perfect. Very good.
Excellent. And Jeff, let's give the number for Paladin if they want to call and get the financial and set up that estate planning meeting through Paladin. I'll give that number for you. It's 651-842-8406, correct?
Yeah, absolutely, yeah.
All right.
Want to give us a call, schedule a complimentary second opinion on your retirement plan, and as part of our process, we look at your financial plan, your estate plan, your taxes. We want to make sure all of that is working well together. Those three pieces of the puzzle aren't working in different directions. So give us a call, and we'd love to set up that time and meet with you and give you some great ideas on how to help you and your family navigate retirement, estate planning, all these great things, and bring Matt into the process as well. So for everyone, happy holidays. Thank you very much. And Matt, thank you very much for joining us.
Thanks for having me, guys.
Yeah,
absolutely.
Pleasure.
It was a great show. And listeners, that does it for today's episode of Paladin Financial Talk with our host, Jeff Foley.
Very good. All right.